It is often believed that the common law of birthright citizenship was that mere birth on the sovereign soil was sufficient to confer such subjectship or citizenship. That is incorrect. Although that statement is an approximation of the rule that usually gets the correct result, the precise rule at common law was birth on the sovereign soil to parents under the sovereign's protection. That is how Sir Edward Coke described the rule in Calvin's case, the leading common law decision from 1608. Aliens from friendly countries with permission to be in the realm, and I'll get to that point, were under the sovereign's temporary protection and owed in exchange a temporary allegiance. They were, while in the realm, natural subjects of the king. That is why their children born in the realm were understood to be natural-born subjects. In contrast, the children born of invading soldiers were not birthright subjects, although born upon the king's soil, because they were not born under the ligiance or connection of a subject, nor under the protection of the king. That is, a natural-born subject is one who is born to another subject, a subject who is under the protection of the king. Invaders did not count, but aliens generally were subjects of the king if they were under his protection and gave him in exchange allegiance. William Blackstone, in his influential commentaries, described the rule respecting foreign ambassadors similarly. Their children were not natural-born subjects because they were born under the protection and within the allegiance of another sovereign represented by the father of the ambassador. To summarize the rule, he is Supreme Court Justice Joseph Story. Nothing is better settled at the common law than the doctrine that the children, even of aliens born in a country, while the parents are resident there under the protection of the government and owing a temporary allegiance thereto, are subjects by birth. The status of the parents did matter, and the relevant status was whether they were under the protection of the sovereign. What is more, in the relevant periods of English history, it appears that an alien could come under the sovereign's protection through one of two ways: through a grant of a royal safe conduct or through statutory permission to enter. Safe conducts were formal legal documents from the king granting permission to enter and specifically extending protection. The examples of these safe conducts using the language of protection are legion. For present purposes, here's William Blackstone's summary. During the continuance of any safe conduct, either express or implied, the foreigner is under the protection of the king and the law. Now, eventually, safe conducts were replaced by statutes. Magna Carta guaranteed friendly aliens safe and secure conduct to engage in trade unless they have been previously and publicly forbidden. A 1353 statute provided clearly and unequivocally merchant strangers may safely and surely, under our protection and safe conduct, come and dwell in our said realm. Even subjects of warring nations could be under the sovereign's protection so long as they had the permission to remain. In an American case arising out of the War of 1812, Chancellor Kent explained the rule as follows: a lawful residence implies protection and a capacity to sue and be sued. In summary, it appears from the historical record that unlawfully present aliens would not have been considered, or certainly may not have been considered, under the protection of the sovereign, and their children may not have been considered birthright subjects or citizens. Now, the case from the War of 1812 also illustrates another important proposition: the connection between protection and jurisdiction. As Kent wrote, not only does a lawful residence imply protection, but it also therefore implies a capacity to sue and be sued. An alien caught at the border may be subject to U.S. criminal jurisdiction, but does it follow that that alien must be allowed to sue and be sued in U.S. courts and to enter into contracts? In other words, such aliens may not have been subject to the complete jurisdiction in the sense of the amendment, as Mr. Cooper suggested. Now, the case of temporary visitors was more complicated at common law. The parents of lawfully present were under the temporary protection of the sovereign. That is why one judge in a famous case held that a child born of temporary sojourners was a citizen. But the rule was contested because of the increased international travel and resulting dual allegiances. Joseph Story suggested that an exception for temporary visitors would be a reasonable qualification to the rule. Henry St. George Tucker, in his treatise, stated that temporary visitors fell outside of the rule. An appellate decision in New York from 1860 strongly suggested similarly. Most significantly, perhaps, the military authorities in the Department of the Gulf had to decide whether, during the Civil War, they could conscript into the Union Army children born in Louisiana to French parents. A provost judge and the commanding general both concluded that such children, though born on U.S. soil, were only liable to the duties of American citizenship, such as conscription, if their parents had been domiciled at the time of their birth. The Louisiana example also suggests ways in which temporary visitors may not be subject to the complete jurisdiction of the United States. Would it be lawful, under the law of nations or international law, to conscript them or their children? The Union military authorities appear to have thought not. In this and other ways, temporary visitors may also not be fully subject to the jurisdiction of the United States in the sense of the amendment. I look forward to your questions. Thank you.
Thank you.